Good morning. Good morning and welcome to the 12th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have received apologies this morning from Maggie Chapman and Evelyn Tweed. Claire Adamson will be joining us in place of Evelyn Tweed this morning. Our first agenda item is to agree to take agenda item 4 in private. Agenda item 4 is an opportunity for the committee to consider its work programme. Are we all agreed? Yes. We're all agreed. Thank you. Our first agenda item this morning is to begin evidence taken on our civil legal aid inquiry. Apologies. In this inquiry, the committee will be exploring what is working and what is not working within the current legal aid system and what changes could be made in the shorter and longer term to address issues about access to civil legal aid. I therefore refer members to papers 1 and 2 and welcome the first of two panels this morning. We have Pat Tom, Convener, Civil Legal Aid Committee, Law Society of Scotland, and Elia Sial, Chief Executive, Legal Services Agency Limited. You're both very welcome this morning. We will now move on to questions, and I'm going to start us off this morning and ask, what do you see are the biggest barriers to people accessing civil legal aid assistance? And I'll come to you first, Pat.
Thank you, Madam Convener. In our response to the consultation, the Law Society indicated that the biggest barrier to accessing legal aid is a low availability and increasing shortage of legal aid practitioners. And I would say that's down to three things. The first is the low fees paid for legal work, resulting in those who have been practicing in legal aid refusing to keep on going because it's just not sustainable. The fact that the low fees are not appealing to the younger solicitors, and as a consequence, we are also facing a retirement cliff edge. By way of background, we baby boomers, which I call myself, were prepared to work 6 days a week, which perhaps camouflaged the financial return or the poor financial return. But those younger than us are far more pragmatic and have a healthier appreciation of a work-life balance. And that's having the effect that younger legal aid solicitors or younger solicitors are not attracted to going into legal aid. Thirdly, the increasing complex and bureaucratic civil legal aid system, I should say. And I'm so glad that in the paper you were provided with contained a section on technical terms, and as that in itself gives you a flavour of the complexity of the system. An understanding of the difference between advice and assistance and civil legal aid is essential as a basic step, but to be fair, it is almost incomprehensible to any newcomer to legal aid. And that, I think, illustrates how complex and bureaucratic the system is. We refer to legal aid deserts, both geographical and by particular areas of law, such as asylum seekers and immigration and employment. Both, I think, are a consequence of the factors I've just mentioned, but are exacerbated by the lack of quantity. If we're in the urban areas and you're going to court on a children's legal aid case, you probably perhaps have 10 cases in court that day. Whereas if you're up in Orkney, you might have one a week, and it's just not financially viable to do it that way. Whereas, and the same with immigration cases, you might have a lot more in the urban areas than you're going to have in the geographical outlying areas. So in essence, in summary, it is the low availability and the increasing shortage of legal aid practitioners that's the biggest barrier in our view.
Okay, thank you. I'll come to you now, Elia. And I should say that you're representing the Scottish Association of Law Centres. Thank you.
Thank you very much. I would agree with a lot of the comments that Pat has made in relation to the legal aid practitioners and the areas of law that they are practising. So from a law centre's perspective, we certainly see that there is a shortage of practitioners that undertake housing, immigration, welfare law, employment law, and a lot of the reasons for that are the administrative burden in terms of the work that solicitors are obliged to undertake and the amount of remuneration that they receive for that. We can give you many examples of where that is disproportionate, both in relation to advice and assistance as well as civil legal aid. In relation to advice and assistance, you have a very small fee rate that you're starting with, and increases need to be applied. They're not retrospective, so you will see very many examples in the papers that are with you, and also evidence that I know that my colleagues are going to give later on today, particularly in relation to immigration. In relation to civil legal aid, particularly around housing and block fees, I would add that there are certain types of cases where block fees don't pay for the work that is involved. So, for example, in antisocial behaviour cases, the block fees are the same as a rent arrears case, but the amount of work that's involved is significantly different. You can have cases where you have over 100 paragraphs in the statement of claim. You have to respond to answers, you have to meet with the client, and the fee that you get for that is just over £100, whereas the work that's involved is a significant number of hours. Similarly, when you are reviewing production of documents, it can be over 100 pages and you get a small fee of £18. So you can see why there is a challenge in practitioners undertaking not to deliver that area of work, because it simply is not paying for what solicitors are obliged to do. I think I'd also add, in terms of the clients that we see through law centres, you may have come across the term clustered injustice, and by that what I mean is that people don't come to us with a single issue. They sometimes have simultaneous issues that are that they're facing challenges with at the same time, and sometimes they solve one thing and it goes on to another. A trauma-informed, person-centred approach is absolutely necessary to be able to support that client, to be able to build trust, and to be able to assist that client in understanding what their legal rights are, and also to help them navigate the various legal processes that are involved. None of that is properly paid for. So you can see why there is a reduction in the number of legal aid practitioners. Now, if people choose to move on to other areas within their career, and practicing in a law centre or a legal aid firm has been their stepping stone to something that's different, that's something to be celebrated. But if people are leaving because they feel that they can no longer cope with the amount of work that is required and what they are being paid for, then I think it's incumbent upon us to review why that might be the case. So I would say that that is one aspect of it. But the other aspect in terms of barriers, I would say, are eligibility criteria. There's different eligibility criteria for advice and assistance, and there's a different eligibility criteria for civil legal aid. The two cannot be looked at in isolation. In advice and assistance, you could have somebody who is on living wage and have no dependents, and they would not be entitled to advice and assistance. That does not put them in a place where they can actually afford to pay for legal advice. With civil legal aids, the processes in terms of the forms that require to be completed to assess the means is fairly complex. Whilst there is provision for passported benefits, I think that does not take into consideration capital limits, which currently are £1,716. It's a small amount of money which quite often people are using as a safety net. To expect people to be able to pay for legal advice through what is a safety net, we consider is not fair. We would also highlight examples, particularly in relation to disabled people, where they may have set aside funds for a particular purpose. So we can give you an example of a client who had set aside funds to pay for energy bills in the winter. That put him above the capital limits, and accordingly was not entitled to advice and assistance. So that sets people back from being able to get legal advice. It sets people back from being able to assert their rights, and I think that those are collective barriers that we need to be looking at.
Thank you. We'll now move on to questions from Paul O'Kane, please.
Thank you very much, and good morning to the panel. I'm particularly interested in terms of the government's proposals which they had to reform legal aid, and there was an intention to bring forward proposals within the parliamentary session. Now that hasn't happened and now won't happen. Obviously what then happened was to build on the Evans review, the government set up a number of working groups. Now, my understanding is that the Law Society withdrew from those groups, and I'm just keen to understand what the motivation was and the view of the Law Society in doing that.
Given that I was involved in all of that, I can really give you a good explanation of that. Initially, I became convener of the Legal Aid Committee just before COVID. And I have to say, the government and the Law Society and SLAB, or the Scottish Legal Aid Board, worked extremely well together for the period of COVID. And the outcome of that was an increase and a resilience fund, and things were working well. We got another increase in fees in July 2022, but that was on the condition that we would work with the Scottish Government on the research project, which was the outcome of the Evans Review, or it was a suggestion from the Evans Review. And so for 2 years, almost 2 years, the Law Society, the Scottish Bar Association, and ourselves, and the Scottish Legal Aid Board met to first devise the tendering protocol for getting this research done and then putting it out to tender. The problem was there was no tenders. So nobody was interested in doing this research for us. And it culminated in April 2024 when it was suggested by the Scottish Government, and I'm not sure whether they meant to suggest this, but they said that even if the research project suggested that there should be an ongoing mechanism for increasing fees, there wouldn't be any money for it, so there wasn't any point to it. And that caused us to pull back. We thought, well, that's... Now, the word was that we pulled back from negotiating with the Scottish Government, but we didn't do that. We just we withdrew from the research project. But the difficulty with that was that for some reason, the Scottish Government decided or stopped talking to us about legal aid. What we were hoping for is at least get some kind of movement forward for the reform, for the increase in fees, and just to continue to look at legal aid. And unfortunately, we were struggling to get the Scottish Government to engage with us. And I think they just said that, well, and they put out the word that it was us that stopped engaging with them, which I think was unfortunate. Fortunately, I think in the last 6, 7, 8 months, we've been doing a campaign, a public relations campaign, to illustrate that what we're talking about and on our biggest beef isn't necessarily trying to get more money for lawyers. It's the effect of the fact that the fees are so low that lawyers are stopping to do it, and that means that people aren't accessing justice because they can't access a lawyer to help them with their work. And I think the reality that's the effect of this of the Scottish Government kind of ignoring the issue made people realize. And so fortunately, the Scottish Government are now engaging with us, and we do have a proposal, as you say, I think at the end of February. Most of those proposals are linked to criminal legal aid, but there are a couple, there's about 3 civil legal aid proposals, which we welcome. It's just tweaking the system. They're merely little tweaks, but we can't say look a gift horse in the mouth, and we certainly were happy to go along with that. And there is some suggestion that maybe those might get implemented before the close of this parliamentary session this year or this summer, and we certainly hope for that. So, but yeah, I hope that explains our position in that.
No, I mean that's helpful, and so just in terms of this piece of research, so that's not going to happen.
So I think what the Scottish Government are now saying is that they're going to look to the research that England and Wales have done, and see how they manage to get the problem with the research is that they need the Law Society to engage with it, because once they find somebody to do the research, we have to persuade our members to cooperate with the research and open up their books and allow the researcher to see how their firms are financed.
And is your sense that the government have moved in terms of that initial position about sort of prejudging the outcome of the research? I think money's back in the conversation?
Yeah. I think they're sort of suggesting that maybe that shouldn't have been said. Yeah.
Okay, that's helpful. I wonder if I can, convener, just one more point. Just, in terms of reform and improvement more widely, how much would you view needs to be in primary legislation? Obviously we're talking a lot around how do we tweak, how do we find things that can be done in other ways, but do you think this requires a fundamental piece of legislation essentially?
I do in the long run, yes. I mean, I have to say, and the paper that you were provided with, in advance, and it lists several very productive and sensible things. As my friend has mentioned, the eligibility criteria, needs to be sort of sorted. The link between advice and assistance and civil legal aid, and all of those things can probably be or hopefully be done without primary legislation. But we do need a big overhaul of the whole thing.
Okay. Do you want to add anything at all in terms of the need for primary legislation, Alia? I don't know if there's...
I think an overhaul review is definitely necessary and long overdue. But what I would say is that there are things that can happen in the immediacy, and that really does need to be looked at.
Thank you. That's very helpful. Thank you, convener.
Thank you. We'll now move on to questions from Pam Gossel, please.
Thank you, convener, and good morning, panel. Respondents to the committee's call for views on legal aid highlighted many issues with administering legal aid. Do you have any proposals which could help tackle these in the short term? Pat, if you want to go first.
I mean, I think certainly simplifying, and as Elia's commented on, the eligibility criteria for certain kinds of cases would help a lot. The other thing, and Evans recommended this, so lawyers, if they want an expert witness or a child welfare report or a psychologist report, and they order that, then the psychologist, and they get approval from the Legal Aid Board to approve that expense, the person carrying out that work fees the solicitor. The solicitor then has to fee the Legal Aid Board, and it's a huge, you can imagine it. And what Martin Evans was recommending is that the Legal Aid Board just dealt with those expert witnesses and the child welfare reporters directly, so that nobody, we take out the solicitor as the middleman, who's bearing the brunt of the administration of all of that, and has the the financial outlay possibly to be concerned about. And if it's already been approved by the Legal Aid Board, then it wouldn't really make a big difference to change the system that way, I would say.
Thank you. Alia, do you want to add anything?
There are significant improvements that can be made into the administrative process. So I think, firstly, in terms of when you apply for advice and assistance and or civil legal aid, the forms and the evidence that you need to undergo, particularly in relation to civil legal aid, is fairly onerous. Not only the information that you need from the clients, and it varies depending on what type of case you're undertaking. There's statements that you need to take from the client. There's statements that you need to provide yourself, and that can be streamlined into a single one process where the solicitor is stating what the claim is and what the legal remedy is that is being argued. So I think certainly that can be simplified. At the moment, people are not able to really navigate the Form 2, which is around the financial eligibility, and certainly our solicitors have to spend time going over that with the client, and quite often people just abandon the process that they're undertaking, and that not only has a negative consequence for that particular individual, but it has a negative consequence of poor practices for the next person. I think on the other side, once you have managed to get advice and assistance and or civil legal aid in place, there's various processes that then need to happen in terms of either applying for increases or sanctions and so on and so forth. So again, that can be streamlined to make that process a lot simpler. And then when you get to the stage of submitting your account for payment, then you also face a lot of abatements, and the abatements have already been authorised, so you're then having to justify again the work that you undertook. Sometimes it's considered that that work is not necessary. sometimes you've had an increase for an outlay, which is then being challenged, which means that you end up being the person who's paying for it. And you can see how this links back to people deciding that undertaking legal aid work is more costly than it is paying for. So those are some of the things that we feel can be simplified.
No, thank you for that. I've got just a couple of supplementaries. The Scottish Women's Rights Centre have highlighted the issue of access to civil protection orders for survivors of domestic abuse. They say that often the burden of accessing legal protection falls on survivors who must access civil legal assistance or pay privately to do so. So could I ask, what is being done to ensure that these women, many of which are extremely vulnerable, receive the right support they deserve?
I think that just goes back initially to the first thing, the barrier to civil legal aid, because the first thing that person or that individual is going to need to do is find a civil legal aid solicitor willing to take on the work. But once they do that, I think probably if we could go back to the eligibility requirements, quite often the situation for the woman in that situation is that she's not really going to have access to her financial situation because of the effect of the coercive behaviour or whatever, and I think you called for this yesterday, that maybe if we just remove that requirement for them to prove that they have that financial eligibility requirement. Certainly, the adults with incapacity regulations allow for that in lots of cases, and I don't think it would be too difficult to move that over to domestic abuse survivors.
Do you want to add anything, Alia, to that?
I think there's a real need to consider automatic grants in those circumstances, so that Pat's rightly given examples of adults with incapacity. I appreciate that there are slightly different circumstances, but there are equivalents in criminal legal aid. So where we are talking about protection for an individual, the fact that they cannot afford legal advice means that they remain vulnerable. And I think that does need to be considered, and it shouldn't be that difficult to broaden the areas where automatic grant of civil legal aid, irrespective of means, is considered.
No, thank you. Another issue is that BAME women, people from ethnic minorities, who face additional barriers as sometimes the relevant authorities find it difficult to understand the cultural context of their cases. So could I ask what's been done to ensure that these women are looked after, and that many of, again, are extremely vulnerable, and that they receive the support that they deserve? And I know that you mentioned there the requirement of financial information, which could be a big issue in many ethnic minorities and BAME communities. The male, basically the husband, or has that financial, let's just say, situation that holds basically all the financial information, and it's not always the female. So again, I think the requirement probably comes into this as well, but also it's a very different setting when somebody from a BAME background goes through this, because you have to look at basically the cultural aspect, but the community as well, because you're dealing with not just the partner or the family, you're dealing with a big community out there. Mm-hmm. So it'd be good if you could shed some light on what can be done there. I
think the response to have an automatic grant would help go a long way. I have to say the Law Society, I think, will probably turn to you for the rest of the answer.
I absolutely agree with the points that have been made in relation to understanding the additional barriers that women from Black and minority ethnic communities face. I think it's crucial that we understand that there are cultural customs that need to be understood. It is absolutely crucial that it's understood that quite often they are not aware of what the financial circumstances are of the family. They certainly would not be in a position to be able to provide evidence of that. And for that in itself to be a barrier to somebody being able to get legal advice, I think is something that needs to be reviewed. Going back to the eligibility criteria, particularly in relation to minority ethnic women. When you are considering capital and savings, you are also taking into consideration jewellery, and that is something quite often which is passed down from generation to generation. For someone to have to think, I cannot get legal advice because I have declared that I have jewellery that is of a certain value, and that I may need to consider selling it to be able to get legal advice to protect myself and or my children, I think really does need to be considered and understood.
No, it's good you've mentioned that, Alia, because obviously jewellery, property, certain things, going back to the BAME backgrounds, I certainly know that there's things that wouldn't be thought of. But now, can I ask, have you had many cases like this that you'd have to face? Because I know, certainly speaking, I've got a bill I'm working on, but I've been speaking to a lot of these communities, and they're saying that not just financially, but other areas as well, that they find a lot of barriers in, because it's not the same situation, that not one size fits all for the services.
Absolutely, sort of reflecting back on my long-term career history, yes, definitely. I can give you many examples where quite often they're not aware, if we even put property and jewellery aside, if you even take of immediate circumstances, they're not aware of what the household income is. For them to be able to even ask that question would create a domestic issue. And I think that needs to be understood, that when you're coming across as, I don't know this information, you're not being vague. You simply do not know that information. And if you are to try and attempt to find out that information, you could be putting yourself at risk.
No, thank you for that information. Thank you, Convener.
Okay, thank you. Tess White has indicated she'd like to come in a supplementary.
Thank you, Convener. I've just got one follow-up question, if I may. It's in relation to domestic abuse. So over 80% of women of those who experience domestic abuse, over 80% are women. And the Scottish Women's Aid, in their submission, said that legal services should be provided free for all women, children and young people experiencing domestic abuse, with no means testing and no qualification on accessing this for women. I'd like to ask you your view, particularly in relation to this point about economic abuse, and where women are told, let's say they might be on low incomes, and they're being given advice by certain parties to say you'd be better off not working, but then if they have to stop working in order to access legal aid, then they're in this cycle of never being able to get out of poverty. And so it's a huge situation that many women who experience domestic abuse, and then they find themselves leaving the family home, and then their partners come after them for maintenance. And I've heard of absurd situations where they've had to leave their family home with their children behind. They're on low incomes, they can't get legal advice, and they're asked to pay significant sums in maintenance. So have you experienced or know of those cases like that? And would you also support Scottish Women's Legal Aid in their call for no means testing at all?
Yes, to all of what you've highlighted. I think it goes back to the need to review the eligibility criteria and the need to review what needs to be an automatic grant and in what circumstances, whether that be people that are on low income, whether that be people that have to consider stopping work. We need to sort of review all of it collectively at the Social Security and Social Justice Committee last couple of weeks, where they have taken evidence. The cost of actually having to leave an abusive relationship was highlighted, which is significant. It was also highlighted that you can find yourself in circumstances where you're not only meeting the costs of your principal home, but wherever you've had to move to. So the costs on the whole are significant. And where we have the current capital limits, expecting people to have to pay for legal advice against something that is set as an emergency safety net, I think is not appropriate, and it does need to be reviewed, and there should be an automatic grant in certain cases.
And Pat, I know you've actually said that as well, reviewing the eligibility criteria. I'm feeling a sense of desperation amongst so many women who are experiencing domestic abuse and the economic abuse. And both of you today, and Pat, would you like to speak to that?
Yeah, and I have to say there's another twist in the tail, which I think has been addressed in the paperwork, but which we haven't mentioned today, is let's say the person does qualify for legal aid and gets legal aid, and that legal assistance assists that lady or gentleman, who the victim of the abuse, to, say, retain the house. Then there's this thing called clawback, which the Legal Aid Board decide that because they've been successful in their action and have retained property as a consequence of it, they're going to have to use that property to pay back the legal aid fees, the legal aid fees that the solicitor's been paid. Now, there is provision for getting exceptions to that, but and it's called hardship, but it is very complicated and would scare people, I would say, and put people off, to be fair.
Thank you. Thank you, Convener.
Thank you. We'll now move on to questions from Marie McNair, please.
Thank you, Convener. Good morning, panel. Alia, good to see you again, just a different committee. The Scottish Government have proposed introducing block fees for adults with incapacity work. I'm keen to hear your views on this, and obviously you touched earlier on in concerns you have about block fees, so if you could just speak about this part. But if you want to expand any further, though, on other aspects of the block fees.
I think I would say in terms of block fees and or any process that is intended to simplify matters, that has to be welcome, whether it's block fees or whether it is templates for increases. But I think what is significant and needs to be taken into consideration is what actually is involved in terms of the work that needs to be entailed and whether the block fees will cover that. I highlighted earlier examples of block fees that are paid in a different context, but in housing, so for rent arrears or antisocial behaviour cases. The block fees do not cover the amount of work that is involved, and that significantly needs to be reviewed. In terms of adults with incapacity, there is a different amount of work that needs to be done if you are representing the adult, and I would be concerned if block fees were introduced without taking that into consideration and the overall sort of principle that I'm outlining, that where block fees are meant to simplify things but do not necessarily take into consideration the level of work that is involved at each stage of the process, whether that be court process or whether that be process that is involved in engaging with your client. It really would, it could have an unintended consequence of deterring people from doing that work if it is not appropriately considered.
Thank you. That's really helpful. Pat, do you have kind of similar concerns? Are you supportive of it? Or,
No, I would agree
grateful to hear
100%. I think block fees for applicants in adults with incapacities probably makes a lot of sense. Having practiced that area of law myself, it's fairly straightforward, and a block fee would simplify things and make life easier. By the same token, as Alia is suggesting, one size doesn't necessarily fit all, and there needs to be real consideration to, to how it's implemented, and maybe, a safety valve of suggesting that maybe this case doesn't suit a block fee, and an ability to apply for a different mechanism for feeing that case.
Thank you. Moving on to my next question, obviously the Scottish Government have also proposed introducing standard personal allowances for civil legal aid. Can you hear your views on any kind of advantages or disadvantages to this approach?
I think that's probably quite useful. The only difficulty is this difference between advice and assistance and civil legal aid, and it just gets really complicated because the eligibility criteria are different for each. The threshold for qualifying, and So it's just not that simple, and we need to be careful about. We just maybe just need to recognise that.
Everyone seems to come back to the eligibility criteria.
Exactly.
Alia, yourself, anything?
I'd welcome further information about what that would entail, recognising the point that Pat's made about one size not fitting all. Anything that's sort of simplifying processes is very welcome, but I think there needs to be engagement in advance of what that would mean in different cases, different scenarios.
Thank you, that's really helpful. That's me.
Thank you. We'll now move on to questions from Claire Adamson, please.
Good morning. Apologies for being late this morning. In terms of the longer term reforms, the Scottish Government have proposed testing different models of delivery. Do you have any views on models such as grant funding or solicitors being directly employed by the Scottish Legal Aid Board or contracting?
I'm personally not a fan of grant funding. The difficulty with grant funding is that it's a fixed amount, which appeals to the accountants of both the Scottish Government and the Scottish Legal Aid Board, but it is a fixed amount, where with the Judicare system that we now have, it's demand-led. And as long as the demand is there, the money has to be paid. And so my concern with grant funding, quite apart from there's some other issues with those, the fact that grant funding seems to, be awarded each year, so those getting the grants have the concerns of are they going to get the money. But my real concern is that it's a fixed amount, and the worry would be that the amount that's fixed isn't sufficient to cover the need, so because it's ring fenced, and once the money's spent, there isn't any mechanism to get any more money, and that would be my concern. So I personally prefer the current system, the Judicare system.
And do you have a view on whether there's an appropriate mix between Judicare provision and other types of funding?
I mean, I think they're probably, and having been a private practitioner, I've always been in the Judicare system, but Amelia will have a good understanding of the grant funding system, and different, and I'll turn to her in a second. And I think grant funding probably is a good stopgap measure, but it certainly can't replace the Judicare system.
Okay. Do you have?
Yeah, thank you very much. I agree with what Pat's saying, that I don't think one or the other can replace each other. But in terms of different models, I do think that you outlined three. I think all three are necessary. They have their own purposes. They have their own advantages. In terms of grant funding, law centres have significant experience of delivering grant funding. We consider that it does give you the ability to be able to provide holistic services. It gives you the ability to be able to collaborate with other partners, so that you're focusing on not only the legal issue, but other support issues that the individual may have, to try and maximise the chance of, I suppose, minimising recurring instances of disadvantage. So from that experience of delivering grant funding, I think that there are opportunities. There are, however, challenges in terms of grant funding. Grant funding has not been reviewed in terms of the subject matter for, I think, well over 10 years, if not longer. The amount that might have started as a cost recovery has not been reviewed for, again, probably that same length of time, if not longer. So what might have been cost recovery then is no longer cost recovery now. There's also the delay in which you receive decisions. Quite often you are receiving decisions in the last quarter of the financial year and or after the financial year has started. Sometimes you have a year's funding, but sometimes you do have either 3 months or 6 months whilst long-term decisions are being undertaken. And you also have instances where you are advised, although the grants have been renewed year on year, saying this is the final year, that in the last quarter you do actually find out that this is indeed the final year. I think there's two aspects of that in terms of the difficulties. It's not just about organisations planning, about their finances, their workloads, and the staff. So, having to undergo processes of issuing redundancy notices and so on and so forth. I think that is not the only issue, and sometimes it feels like that is what sort of the priority seems to be, that this is something that you should have planned for. I think what gets forgotten within that mix is you have clients who you have commitments to. Their case may not necessarily end in the next 3 months, and it sort of limits your ability to start feeling nervous about taking new cases. There isn't anywhere else to send those cases. So you find yourself in very difficult circumstances in making sure that you are looking at what needs to be done practically from an operational point of view, practically from the obligation you have to your staff, but also practically in terms of the commitments to people that are already your clients and the challenging circumstances for those who you have to be careful about not taking on.
Thank you. I've got a final question on the Scottish Government's intention to embed user voice in the planning process for legal aid delivery. Do you have any views on this and how it might be achieved and what that impact might be? And if I could just refer to my colleague Marie and her question, I have a particular issue with how adults with incapacity could be embedded in that process.
I mean, I think that's an excellent idea. I think probably the users should be embedded in the process. As far as adults with incapacity goes, yeah, I'm not quite sure. So what do you see the issue there?
Just in terms of being able to advocate for themselves within a review process and take part in that process.
I mean, in that situation, it would be more the applicants who are applying for, say, guardianship, who would be applying. They would be the user for the legal aid. So obviously, they're looking out and representing a very vulnerable group. But I think they would be well able to participate in a consultation.
Yeah, anything to add? Yeah.
I'd agree with what Pat said. I think it is crucial to take the experience of those that are providing legal aid, but also those that are legal aid recipients. And I think sort of that combination of lived, learned experience is crucial to take forward. And I think in terms of that lived experience, it's very important also to see how that information is captured so that we're sensitive and we enable as many people as possible to be able to participate in that. So it really needs to be meaningful.
Thank you. Thank you, Convener.
Would any other members like to come in and questions? Yes, Tess White, please.
Thank you. So in terms of wrapping up, got the last few questions for you. If I can go to Pat first. Pat, if you had to say and look at a future vision for legal aid, what action would you say that needs to be taken?
I suppose there's two things, and certainly there needs to be a huge financial investment in legal aid, and I fully appreciate that an increase in fees wouldn't be sufficient to solve the problem, but it would go a long way. The legal aid solicitors are currently feeling extremely undervalued, and a lot of that comes from the process itself. Alia has mentioned the abatement process, and really it's so frustrating for a solicitor to have gotten approval for a case and the amount to spend, and they put their bill in, and then it's bounced back, and invariably you go back and forward and spend a lot of time that you're not paid for, and eventually the legal aid board decide, yes, you do deserve that money. And so it's that respect and that trust between the legal aid board and solicitors that needs to be improved, and I think an increase in fees would make legal aid solicitors feel much more valued, and I'm not sure that it would actually attract more solicitors into the role, but at least it would goes a long way to retaining those that are there doing it now. But by the same token, the system is far too complicated and complex. And I think, the information you've already been provided in the paperwork, it shows how complicated and bureaucratic it is. And it just, It just needs an overhaul.
Okay, so more funds and simplify the system.
Yeah.
And Alia, your view?
I agree with those comments that Pat has made. I suppose a couple of other things I would add is we're talking about legal aid practitioners reducing. So we're talking about what might we be able to do to increase legal aid practice. Pat's rightly mentioned about ensuring that people are paid for the work that they need to undertake. We've talked about simplifying the process as well. But I think I'd like to touch on what has happened previously, but it's not clear what the next steps are. So, for example, the Scottish Government had a legal aid traineeship scheme during the pandemic. It was a small number of trainee positions, and from my understanding, they were taken up literally within 24 hours of the scheme opening. There has been no evaluation of how well that worked from both the firms that provided those traineeships or the trainees that undertook it, and how many of them actually then continued to remain. As a firm that was involved in that process, I would welcome the opportunity to be able to share what we considered as feedback. And I think I'd also welcome future opportunities such as this, but those that properly cover the full cost of the trainee's salary and also take into account the supervision that needs to be put in place. In the submissions that we've put forward, we've highlighted the disparity in terms of if you're taking legal aid, what you get paid for compared to, for example, private practice. So if you are supervising a trainee, you're not paid for that. Whereas if you were paying for private practice, you would get charged if the solicitor was supervising. So I think that is something that would be welcome in terms of how well did that work, what did we learn from it, and what do we want to do next from it. The other thing I'd like to point out is that in terms of legal aid rates, there is no distinction between whether you're newly qualified and or you have you're an accredited practitioner and or the number of years, which is again a disparity between private practice. So I think that I'd welcome that to looked at again. Through the course of the session today, we've talked about the Evans review, we've talked about the payment panel, and we've also talked about what further research and evidence might be necessary. What I would suggest is that the Evans review took place in 2017. I think the payment panel was a couple of years after that. We're now in 2025. Any further research that we undertake is not going to tell us a better picture. Whilst I'm sadly very fond of data and very fond of making sure that we make evidence-based decisions, I think we've come to a point where any new evidence is not going to tell us a different story, and what we really need to do is be able to see what are actions that can be taken in the immediate term and what actions are sort of mid to long term. And I think just the final point I'd like to make in terms of, we talked about today about certain circumstances in which an automatic grant would be necessary, and we've talked about domestic abuse, but the two other cases that I would like to highlight is street homelessness. That in those cases, I think it warrants considering whether an automatic grant would prevent that person from enduring further hardship and indeed prevent further cost to the public purse in different sectors. And the other one that I would say really needs to be looked at is around equalities and disability. Quite often people are, I gave examples earlier where somebody might not be entitled because of savings that they have put aside for a particular purpose, but that does preclude them from being able to exercise their rights and indeed develop equalities and disabilities because there isn't that case law, there isn't that challenge. So poor practices continue to be poor practices. And whilst I said final point, there's one other that I'd like to bring in, which is in relation to clawback. We've talked about clawback in relation to property, but clawback also applies in relation to employment cases. and there are very few practitioners that actually represent the employee, and for any settlement that the individual receives, whether that's outstanding wages and or any compensation payment, the clawback can deter people from getting legal advice, which goes back to what I was highlighting earlier. It's not just poor employment practices for that individual, but it's poor employment practices for the next employee and the next and the next.
Thank you. Anything else? Has
Thank
that
you.
covered it? Thank you. Pat, any final points that you would like to make?
No,
Any
yeah,
issues?
I mean, I agree 100%, and Ali is absolutely right with it. And the employment law situation in clawback is crucial, because let's say the award's £2,000 and it's cost £3,000 in legal fees. That person's not getting anything, because the Scottish Legal Aid Board will claw back the £2,000 in compensation, and so what's the point of even doing it? So it is important, but I mean, I think I think I've said my bit. I think I'm happy with.
Thank you. Just go back on employment. Is there no role for ACAS?
Yeah, there certainly is, but it's when ACAS can't resolve the issue, and then it actually goes to a tribunal, then that's when the clawback will be an issue.
Okay, thank you. Thank you. Thank you.
Thank you. Are members content that they've asked all their questions? That's great. Thank you once again for your participation this morning. That brings our first panel to a close. We will now suspend briefly for a changeover of witnesses. Thank you. I'll just... I would now like to welcome our second panel this morning. We have Sally Mayer, Principal Solicitor, Shelter Scotland, Yo Shin, Senior Policy Officer, Citizens Advice Scotland, Andy Cyril, Partner and Legal Director, Just Right Scotland. You're all very welcome, and we're going to move on straight into the questions this morning, and I'm going to kick us off. And I want to ask, what do you think are the biggest barriers to people accessing civil legal assistance? If I can start with you, Andy.
Thank you very much for the question. The main barriers in our submission are most definitely lack of provision and the financial eligibility. But it's important for us to recognise that when we're talking about barriers to accessing legal aid, we're talking about people in your constituencies, in your districts, in your areas, who have issues, who are quite often very vulnerable and are unable to access a solicitor to use any remedy that might be open to them. There might very well be remedies open to them in the law, on the statute books. But if you cannot access a solicitor, then quite often those remedies are meaningless. And so, you know, it can be easy for us to get embroiled in the technicalities around legal aid. But I think I'd like to start by just recognising that we're talking about people here on low incomes and quite often vulnerable people. The question as to why there's a lack of provision, well, that was documented quite well in the first panel. Fee rates are very, very low in legal aid comparative to, well, most other sectors, but including the private legal sector. They're not differentiated between levels of experience either, which, you know, that was touched on in the first panel, but that is actually one of the big issues, I would say. In no other industry do you have a person with 1 week's experience accruing the same fee rate as a person with 25 years of experience. It simply doesn't happen. Legal aid businesses are therefore placed in a position where they need to try and attract senior people, and I assume therefore pay them a senior wage, but they have no means whatsoever of accruing the income, the revenue, to actually pay them. This is why private legal aid firms struggle so much. In order to raise those funds to pay senior or retain senior people, they have to do private work, and that means they're not doing legal aid work. Okay, so this is basic economics of it, I would say. Competitive salaries or salaries that are uncompetitive with other public services, including those operated by the state, are another key area where legal aid practitioners effectively move to the other side. They go to work for local authorities, they go to work for the Legal Aid Board or the Public Defender's Office, and they get paid a significant sum of money more, ironically from the same paymaster. It's inequality of arms at its heart. We can give you some examples around that. The complexity of the system as well, which was, you know, I'm sure we're going to talk about for the rest of the session. All of this means that there are an insufficient number of legal aid practitioners left. The Legal Aid Board itself has acknowledged this, that the pool is shrinking, the expertise and the specialism of those is increasing, and that's because we don't get paid for basic things like legal research, etc. So the pool of solicitors is shrinking, which is a key barrier for your constituents, well, in every area, I would say. The eligibility criteria is the second big barrier, extremely low. If you can think for a moment about the cost of a legal case, I hope none of you have had to go through it, but you're looking at anything between 25,000 to £500,000. If if you have £1,718 in your bank account, you're not getting legal aid. Right? That doesn't make any sense. the economics of it are worlds and worlds apart. So that blocks out a huge number of people from accessing legal aid. So the eligibility criteria are essential for reform. I'll stop there.
Okay, thank you. Yoshin.
Yes, thank you very much for the question. The legal aid system, from our point of view as Citizens Advice Network, should really enable people's equal access to legal advice and representation when they need it, to a fair hearing before independent courts and tribunals, and to an effective remedy when things go wrong. I think this, I want to really highlight this point about the remedy. We often talk about accessing, but it's also about how do we really right wrongs? What do we do when something has happened that is that has gone wrong? And we know that the Scottish legal aid system enables a more generous provision of legal assistance than, for example, in England and Wales, and we really commend that and welcome that. And at the same time, we see time and time again that there are too many people for whom the current system just isn't working. So that means people who are unable to get legal advice, they need to enforce or protect their rights. People are forced to represent themselves in court or a tribunal. And often people who are left unable basically to seek or achieve justice, and they're just forced to suffer rights breaches and detriment. We are not providing legal advice. We are providing advice on legal issues, but we're not providing legal advice. So, but I think we play a crucial part in the landscape of advice giving in Scotland, and work very closely together. All the local bureaus will work very closely together with other third sector organisations, with law centres, and so on, to make sure people have that access to justice. But the barriers are really immense. I mean, if you really look at people's justice journeys, if you look at, where do they go from experiencing a really huge problem, and Alia has mentioned in the first panel these kind of clustered injustice, how they happen. And I think as citizens, as a network, the bureaus are really good in providing that kind of person-centered, holistic advice, always advising on, a whole range of issues simultaneously, to ensure that that person can really move forward and find solutions. And we see, lack of knowledge and information more generally in the general population about rights, about mechanisms to achieve or seek remedies. The lack of legal aid solicitors, we've heard about the many reasons why that is the case in Scotland. Administrative hurdles and barriers, especially eligibility criteria, and restrictions, particular restrictions on the scope of legal aid, kind of all leading to huge legal aid deserts for people, and people being really left to their own devices, and often really that means they can't go anywhere with it. I think we will go into a lot more detail throughout the session. So.
Thank you. Sally.
Thanks for the question. In terms of the barriers to provision of civil legal aid, I think that the primary would be the delay in taking steps to look at both the fee structures, which render much of legal aid work unsustainable, but also the administrative burdens in the provision of legal aid. What that amounts to is we do have a lack of legal aid lawyers. And if I could give a real-world example of that, at the moment we have rising numbers of cases of street homelessness, particularly in Scotland's largest cities. There is an effective remedy to that situation if you can access a lawyer. But I know, particularly in places like Glasgow, that there simply aren't enough lawyers at the moment to allow people to access that remedy. And underlying that is because the fees often mean that you're either operating at a loss or not able to recruit the number of solicitors that you need because Judicare, for example, may not cover the cost of doing so. Over and above that, also the eligibility thresholds, particularly for advice and assistance. And again, if I could just give a real world example of that in terms of what I've experienced in the course of providing advice. So you may, it's an incredibly difficult situation when you have to say to someone who perhaps could be working in an area such as social care that their income, although moderate, takes them just over the threshold and you're unable to assist. So certainly the eligibility thresholds need to be looked at.
Thank you. We'll now move on to questions from Paul O'Kane, please.
Thank you very much, Convener, and good morning to our panel this morning. Particularly interested in developing the theme around, I suppose, unmet need and trying to better understand unmet need for legal aid. So I wonder if it would be possible maybe just to start there and to get a sense of, in a bit more depth, where you think there are unmet needs within, obviously, your specialist interests. So I'll maybe start with Andy, if that's all right.
Mm-hmm. Yeah, sure. One thing I would say, when we talk about research around legal aid and research into unmet need, etc., it can be really difficult to get that rich data, because the reality of a legal aid practice, or a practice that's reliant on legal aid, is that they are time poor. They are needing to be in front of a client almost at all times in order to even exist. So it's difficult to carve out the time and space for that. However, in our practice, there are clear areas of unmet need. Immigration and asylum is a significant one. There is a core of specialist lawyers that are largely based in Glasgow. In Edinburgh, to my understanding, there are 2 immigration and asylum legal aid lawyers. I believe there is one in Dundee, and in Aberdeen, where you have over 700 asylum seekers currently housed by the Home Office in hotels, you have 0 immigration and asylum lawyers. These are vulnerable people, more often than not, don't speak English, mental health difficulties, sharing rooms, so no confidential space for a lawyer, and almost none of them have even met their lawyer. They're trapped in a process where they need a lawyer. Right, a clear area of unmet need. Domestic abuse is also a significant area. We're the legal partner for the Scottish Women's Rights Centre. Our solicitors field helpline calls, legal surgeries, and represent women as well. They estimate through our helpline that women have contacted between 30 and 50 solicitors before they can access advice. Extremely challenging areas there. We may well speak a little bit later about the protective orders issues there as well. And then finally, in our equalities and human rights work, there is precious little advice out there. The people that contact us, and we receive dozens and dozens and dozens of referrals every week. We turn away well over 90% of people that come to us purely because we cannot see everybody. But particularly when it comes to issues like disability discrimination, there's precious little service out there that provides a free legal service. So, people are forced into the 3 options, aren't they? They're paying themselves, borrowing money, going into debt, representing themselves, which happens very often, actually, to the detriment of the justice system, and or which is probably the most common one, do nothing, succumb to the legal fate, and that means that the breach, the statutory breach, the human rights breach, the issue continues. So in our practice, those are the 3 main areas where there's a dire need.
Thank you for that, Andy. Certainly the Social Justice and Social Security Committee, of which Ms McNair and I sit on, is doing work around financial abuse and domestic abuse in particular. And, I think we've heard some evidence already around that challenge of trying to find a solicitor in a very, very difficult set of circumstances very often, and having to go around lots and lots of different solicitors to try and just find someone who might take on a legal aid case. So obviously Citizens Advice acts as a sort, maybe a front door to some of this. So I don't know if there's any reflections on that wider piece.
Yeah, I think it's always difficult to kind of quantify unmet need. It's that kind of really difficult question, isn't it? But what we can see is that in 2023-24, we've seen like the bureaus in our network have given out about 2,700 pieces of advice on legal aid. That was up 17% from the previous year. And half of these legal aid queries dealt with questions around accessing or finding a practitioner. And we also see in kind of qualitative data that comes to the Citizens Advice Scotland from our local bureaus, what they highlight is that there are widespread issues with accessing practitioners willing and able to take on a case funded by legal aid. There can be, alongside issues with the lack of practitioners working in certain geographical areas, as we've heard, or in specific legal kind of fields. This can be especially problematic for those in remote and rural areas, but it's not confined to those. We've also seen, in particular specialisms, a lot of problems in the Central Belt. We see a dearth of practitioners in more specialist areas like immigration, asylum, family law, cases involving domestic abuse, and employment, social security, housing, and human rights law. There's also concerns about a lack of practitioners with expertise in specific proceedings like judicial review. And so all of these can lead to really significant disadvantage for parties involved. We have a lot of evidence of cases where, people are really struggling to find solicitors, especially if their case is judged to be more complex, or they have a more complex case history. We've heard in the first panel why this might be the case. We also see that there are often intersecting barriers for specific groups, such as those with English as an additional language, with an immigration status and/or additional support needs. And I mean, the network, we have several bureaus that run grant-funded projects. So again, that is, they kind of in-court advice projects that were pioneered by the network and were really developed to meet an otherwise unmet need. So this was often volunteers in the network who were maybe retired practitioners and who could offer that specific expertise to help clients. But I think we will come to the grant-funded projects later once more. So, yeah, these kind of are really significant gaps that we see and barriers that need to be quite urgently addressed.
Thanks. Sally, I wonder if in your contribution you might reflect on, we've spoken about advice deserts, both geographically, and I think we've heard about rural, but in terms of specific subject matter, and obviously housing is one of those. And Parliament, and government have declared a housing emergency, and I think it would be useful for committee to understand how much a lack of advice and a lack of legal recourse is having an impact on that wider picture.
Yes, of course. Well, I mean, one of the starkest examples, I think, within housing law is certainly the increase in people having to represent themselves in court due to being unable to access a solicitor. That can be particularly the case in rural locations, and we'll come on, no doubt, to speaking about grant funding and how we do operate a grant-funded project which can address that to a certain extent, but certainly there is sometimes a perception that a housing law case is something which can, where someone can represent themselves or they can rely heavily on lay representation, but actually these cases can be quite complex. And the difference between having a solicitor and not is that we may look at the case in a wider sort of round and pick up on perhaps arguments around discrimination as an example. So that would be one of the most pressing unmet needs within housing law, certainly, is access to solicitor and proper representation within court. In terms of the housing emergency, I have already described the situation we see in Scotland's biggest cities and how unmet need is quite frankly access to that solicitor that can provide help you to seek an effective remedy. the law that's used there is particularly complex. We're talking about judicial review proceedings at the Court of Session. So to say that that can be done by any other means than access to a solicitor would be misunderstanding the laws that are there to be relied on. So that would be the most pressing situation for us in terms of the housing emergency, is just the increase in street homelessness because of that. And yeah, I mean, it's often said that Scotland has the most progressive homelessness legislation, and it does. But at what point are you really not able to enforce that progressive legislation because of supply issues, because of lack of social homes, but also because of lack of the solicitors there to help you enforce your rights?
I wonder if I can just finally, Convener, I'm quite interested in the situation around public debt and around real challenges in terms of public debt, and I suppose the legal options that are open to people to try and get themselves in a better position in terms of the debt they owe to public agencies. I mean, very often that will involve a degree of legal advice, and certainly I've spoken to firms local to me in my region who do a lot of that work pro bono very often to try and support people, even just to have that initial discussion with the council or whoever it is around getting into a payment plan. But is that something, I suppose, Sally in particular and Hugh have seen through your work?
Yeah, I mean, certainly in terms of eviction, particularly obviously in the social sector, we will work closely with money advice organisations such as Citizens Advice Bureau. So we will do that, and that is an absolutely key part to a defence. And we will encourage, often that advice should be offered by social landlords. There are pre-action requirements that require to be taken in advance of raising eviction proceedings. And we have, very regularly, we are able to challenge eviction proceedings because those steps have not been followed. And largely those steps are geared at finding that advice that's needed. Is it the money advice? Is it debt advice? Is it welfare rights advice? So certainly that is a huge and pressing issue in terms of why we see increasing rates of eviction. But also against that, you have to consider the cost of living. And yes, there is access to money advice, but at the same time, people are in incredibly difficult situations that even with advice, it's quite difficult to get out of.
Do you want to add anything, Hugh? Or
Yeah, I think I would echo what Sally just said. I think in terms of public debt, council tax debt is, I think, the biggest debt advice area in the network. So there is a huge amounts of people who cannot afford to pay it, and who are subjected to very heavy going debt collection practices. Yeah. And often there's no real way for them to get out of that cycle. Yeah. Yeah. So within CAS, there's the financial health team that does a lot of work, working with local councils, trying to influence how and improve how these debt collection practices work, to ensure that people have more support, that councils are also aware of those situations and find ways of negotiating payment plans and so on very early on. So generally this kind of early intervention and prevention aspect, I think, is really important. And that's true for other areas as well, not just for public debt.
Thank you. Grateful, Convener.
Thank you. We'll now move on to Maureen McNair, please.
For your time. I'm going to stay on the same kind of line of questioning from the first panel, and obviously the Scottish Government are proposing to introduce block fees for adults with incapacity work, and I'm keen to hear your views on any advantages or disadvantages to that approach. I'll start with Andy, if that's possible, if you've got any views.
Sure. So I would defer to the evidence given by Aliyah this morning on adults with incapacity, on the basis that my organisation does not work for them. I would say that I would agree that block fees are a positive measure, presuming that they cover all the work that needs to get done. What I would say more generally, though, about block fees is that the use of block fees, or what we would call templates, where you open up a file for a person and you get given £1,000, or you get an authorised expenditure limit of, say, £1,000 to do a piece of work. They are vital reforms that need to be made. The use of those needs to be increased without any question at all, because they provide us with flexibility in order to do the necessary work that's required. At the moment, they're pretty rare, to be honest with you. Instead, we operate under what's called the increase system. Now, the increase system, to be honest with you, in my experience of doing this work for 12 years as a legal aid practitioner, it's kind of normalised, but it really shouldn't be. The increase system requires you, when you get to your desk in the morning, to make a request on the legal aid online portal for every single piece of work that you want to do for a particular client in the coming days. You need to mark it urgent, because if you don't, then it won't get looked at that day at all. It will take 3 or 4 days. But I'm talking about every phone call, written correspondence, meeting, outlay. Now, if you think about your caseworkers, right, in your offices, and them having to spend time doing that, it's a complete waste of time. It's completely inefficient. If we were able just to get a template or a block fee, then that just frees us up to do a lot more spending time on the client as opposed to spending time with the Legal Aid Board. So it absolutely has to be the case that we move in that direction. The alternative is that we change radically how the Legal Aid Board looks at our accounts, because what we have right now is a double audit. Right? We ask for permission for every single meeting and call, and then we do it up to the limit that the Legal Aid Board allows us. And then at the end of the file, we have to submit into the legal aid system every single telephone call, the time that it started. It started at 3:15 and it lasted 4 minutes. We have to put that in. We have to put in every single outlay, every single meeting. And so we're getting audited at both sides, even though it's already been approved. Legal aid practices need to employ people simply to do that back end of the process with the Legal Aid Board. So you're having to spend 50, 60, 70,000 a year just to get some money out of the Legal Aid Board, because of the way the system works. Now, all of this is a complete waste of time, because what we want to be doing is working for the individuals that are accessing our services. Your question earlier this morning, Pam, about taking into account trauma-informed practice, gender-informed practice, working with folks from different cultures and backgrounds. Practitioners will struggle to do that kind of work because it's not paid and because they're spending so much time dealing with the Legal Aid Board. So block fees can seem like a technical thing, but actually when you break it down into your day-to-day lives, practitioners in any other industry are not doing this. It's only us. And it is taking us away from actually dealing with the issues we're supposed to be.
No, we'll definitely simplify the process there. Ho, do you have anything? Sorry.
Well, I think because we are not legal
it's okay if you don't,
so
just passing over. Sally, yourself, do you have anything?
Yes, well, I would say the same as Andy. We don't provide advice in relation to adults with incapacity. However, we do regularly work with template increases and block fees. Okay. So I perhaps come in on some of our experience there. Again, we would echo that largely that is welcomed. Template increases, for example, allow us to get on with the work we want to be doing rather than constantly seeking prior approval from the board. In terms of block fees, we work with block fees where we're defending eviction proceedings in the Sheriff Court, and that would be social landlord evictions. So what happens there is we grant advice and assistance, and we also apply for civil legal aid. Civil legal aid can take around 6 to 8 weeks to be granted. It can be longer if you're gathering the significant amounts of evidence that need to be submitted for that application. And what happens is you have advice and assistance, which largely allows you to negotiate. It covers you for that side of things, so negotiating settlement. but it's not always possible to conclude that by the time that civil legal aid is granted. And once civil legal aid is granted in that circumstance, you move on to block fees, which don't allow room for payment for negotiation, for example. They're very much focused on the appearance at court, and in reality, you might still be seeking to negotiate. For example, if you are still awaiting information, so you might have to seek someone's housing file by way of subject access request because it's not forthcoming from the pursuers, from the social landlord, and obviously that can take time. So while block fees are definitely welcomed, you know, there is some argument that some of the work that we would like to continue to do becomes not paid for once block fees are in place. So in terms of the written submissions that have been made to the committee, both the Law Society of Scotland and the Faculty of Advocates recognise this in a more general level. So I think when the Law Society have recommended that you could look at something around allowing advice and assistance to continue in conjunction with the block fees and civil legal aid, and the faculty have sort of noticed that generally civil legal aid is not reflective of current practice, which is for preparedness and for settlement. Certainly in our work, we would never want to put our clients through a full evidential hearing where they're to go to court, give witness evidence, and a reflection sometimes of them, you know, experiencing particular vulnerabilities, and it just being, you know, if that process is not necessary, let's settle this and get a good resolution. So, yes, so the block fees certainly welcome, template increases welcome, but we have come across some issues in terms of there being some level of essentially unpaid work under the block fees.
Thanks for that. Can I stay with you for my next question? Scottish Government are also proposing to introduce standard personal allowances for civil legal aid. Do you support that approach?
Well, yes. I mean, in principle, we support any approach that is going to relieve the administrative burden and make civil legal aid more accessible. But as with my colleagues earlier, I probably want to have a bit more of a robust understanding of how that would work in practice.
Thank you. That's me.
Ma'am Gossel, please.
Thank you, Convener. Good morning, panel. I was just saying, it's good morning still, yeah, good morning, panel. This is something I asked the previous panel as well. The vast majority of domestic abuse survivors are women, and as the Scottish Women's Rights Centre have said, survivors of domestic abuse often struggle to access civil aid and many times need to pay privately to do this. A panellist from the previous session told us that the fact that women cannot access civil aid makes them even more vulnerable. Through my Prevention of Domestic Abuse Scotland bill, I have spoken to many survivors of domestic abuse, with their abusive partners often controlling the household finances. That being said, they might not be eligible for legal aid as their household income may be too high, and sometimes they don't even have that information to hand. So can I ask what is being done to help these women from becoming even more vulnerable? And over to yourself, Andy, because you mentioned earlier on that sometimes these women have to go through the helpline, 30 to 50 solicitors by the time they get through. So
yeah, that's right. So it's a really difficult area to be working in. The Scottish Women's Rights Centre's own submission to this inquiry focused on protective orders, and gave some suggestions around automatic legal aid for protective orders. And I know we've already heard about the position put forward by Scottish Women's Aid around automatic, waiving means testing, which we would be in support of. We do encounter issues around women who have experienced financial abuse or who are still experiencing financial abuse. Post-separation abuse is particularly prevalent. It can bump up against the structures and the administration of the Scottish Legal Aid Board. If there are assets, but assets unable to be accessed by the woman. If there is technically money, but not possible to access it. But there are also ongoing issues where legal aid, even if it is granted, can be challenged by the abuser. Routine. We have issues where even if there is legal aid granted and even if it's not challenged or the challenge is overcome, the court system itself can end up being used by the abuser to continue the abuse, prolonging dates, looking for hearings, looking for adjournments, moving the cases sometimes from the sheriff court to the court of session where the expenses are significantly higher. And this really plays in to sort of jeopardy for women, particularly those who've experienced abuse because of clawback. And clawback was spoken about this morning at length by Pat and Aaliyah. The Scottish Women's Rights Centre was set up as a grant-funded project. The original idea behind it was to try and capture those women who just miss out on legal aid eligibility, but obviously cannot afford their own lawyers. Well, the issue is it's a relatively small centre. There's only 2 solicitors within it. Now, and so demand far outstrips the possibility of supply. I think if we zoom out and look at the logic of a solution to the eligibility criteria for women who've experienced domestic abuse is a grant-funded project instead of expanding the eligibility criteria, that doesn't make a huge amount of sense, I don't think. Now, the grant funding is essential for the Women's Rights Centre, and it's essential that it exists because it does beyond legal representation and one-off legal advice. But nonetheless, you know, there are broader reforms that need to be put in place to make sure that women who need protection are able to access it.
Thank you, Andy. Can I go back to you mentioned earlier on to somebody else's question in relation to the not having the time, basically, to even look at cultural or community differences and how to adapt to them. So do you want to expand a little bit more about that?
Yeah, I would say, you know, goes without saying that our practice does. You need to understand about Just Right Scotland. We're a law centre, so we use the legal aid system every day, but between legal aid income and grants, it makes up 18% of our revenue. We're topped up by charitable funding, and it's using that funding that we're able to provide the enhanced legal service that we do. We work specifically with migrant women affected by domestic abuse, even outside our Women's Rights Centre project. We run legal surgeries, etc. And so we do have the flex in order to put in a lot of the extra hours and a lot of the extra work to make sure that those women feel that our service is accessible. The challenge is, if you're just operating using legal aid, and this is the same for working with children, for example, so much of that work is not paid. So if you're a private business, private legal aid business, it's not clear to me how you're going to make it work in those circumstances. And you know, the Scottish Women's Aid and other domestic abuse services will tell you that there are challenges that women have in accessing services and accessing appropriate services, and you know the sort of nature of the advice they receive, unfortunately. And it's not because solicitors don't want to do it or can't do it. And I think a great number of them can and do, but they're doing it on their own dime, so to speak. The system is not designed to help them in that manner, and that's challenging.
No, thank you. Is there anything you'd like to add?
Yeah, I could. Our submission kind of included the case of Sarah, and I'm just going to illustrate maybe the problem that you're also getting at. So Sarah is a survivor of domestic abuse and has had to flee for her own safety and that of her 12-year-old son. She's legally married. Her husband has the financial means and resources to employ solicitors who have been advising him. Sarah has left with nothing and does not. All the marital property was left behind. There are 2 properties from the marriage with an estimated value of about £260,000. However, Sarah has no access to these without legal assistance. No solicitor will take her on without payment. because of the assets, she cannot apply for benefits which would entitle her to apply for legal aid. Even though the assets are attributed to her, there's no way she can access them without the assistance of a solicitor to do so. As it stands, the client is in the dilemma of having assets which are regarded as capital, which bars her from legal assistance, but which she cannot access without legal assistance. So this means the abuser has recourse to use the law, which has enabled him to retain all the assets from the marriage, while Sarah is left with no assistance whatsoever to help in her situation, thereby enabling a degree of coercive control to continue. So these are, I guess, we see many of these cases. And I do want to acknowledge there's, I think, been quite some recent work by SLAB around the process for applicants who have had to flee abusive or controlling relationships. And I think they have some sort of new guidelines put out, and they say there's more discretion to maybe waive certain evidence that applicants need to provide as long as they can kind of set out the reasons why this isn't possible in the current situation. And I think these are kind of steps in the right direction, but there needs to be a lot more, monitoring of, is this really helping people, and a review of such provisions that might be helpful to see can they be applied across the board to other situations as well, where people are really struggling with the application process.
No, thank you. Sally, is there anything you want?
Well, we're not directly engaged in advising around the types of orders that are being described. I would say that we would strongly support the calls being made by our colleagues at the Scottish Women's Rights Centre. And I would also just like to highlight that often when fleeing domestic abuse or coercive control, that does result in homelessness. And the calls being made for an automatic grant of legal aid in relation to protection orders is also something we would like to make in relation to homelessness generally. When you're experiencing street homelessness, it's very difficult to pull together the financial information, just as it is in the situation where you're experiencing domestic violence or abuse. And yet, I would be happy to follow up on proposals for that, or perhaps there's an opportunity to discuss it in more depth. But there is opportunity here to either simplify the system in terms of the grant of legal aid, either with automatic eligibility, which would mean that when we're advising people who are experiencing street homelessness, we don't have to go through the significant burden, both for us as solicitors and for the user, in terms of pulling together bank statements, completing multiple forms, things that just might not be available. And when we talk about a street homelessness case, we are talking about acting in under 24 hours, 24 to 48 hours, and largely some of our advice will have concluded. So there are other, if not a full-scale automatic grant, there are other lesser steps that could be taken, such as looking at how special urgency is granted. That allows us to, while we await the grant of civil legal aid, for example, it would allow us to raise a petition for judicial review at court urgently to address someone who's sleeping on the streets or in very difficult or unsafe conditions. At the moment, we have to routinely justify why we're doing that. There are differences in types of special urgency, and we could look at some reforms there to make that system a bit easier.
No, thank you. Thank you, Convener.
Okay, thank you. We'll now move on to questions from Claire Adamson, please.
Thank you, Convener. The Scottish Government has indicated that it supports a mixed model of legal aid provision. What are your views on the strengths and weaknesses of this approach? And maybe go to Sally first.
Yep. Well, I welcome the commitment to a mixed model. It's something we operate at Shelter Scotland, so we engage in both the recipient of grant funding, but also provide legal advice and representation through Judicare. Myself, I've also worked across all of the various models, having worked for the Civil Legal Assistance Office, and more recently within Shelter, moving into my position as Principal Solicitor, taking over management of grant funding. And so I know acutely that each of those systems have differences, and the balance between them is welcome. I don't think there should be a particular preference to one, other than I would say that, you know, grant funding is welcome, but it's not to the extent where we're lessening the provision of duty care, which is demand-led and has certainly probably a greater degree of flexibility. Certainly, for us at Shelter Scotland, we do look to test the law. We have a strategic outlook, and duty care is often where we'll have the ability to assist people to do that.
Thank you. Jo, would you like to come in?
Yeah, I think, you know, amid the current lack of legal aid solicitors, and as we've discussed already in previous questions, I think that the judicial element is really, really important, but is just unable to sufficiently meet existing needs for legal advice and representation, and it's leading to denials of the right to access justice. So I think the mixed model has a big role to play, and I think there could be, I mean, if you look at the figures, I think it was about £2.3 million, for example, allocated to grant funding out of a total budget of 53 million or so. So it's a really small amount. But we do see that grant-funded projects can plug some immediate gaps. You know, they will never be the answer, but where there are immediate gaps and there's a lack of a mechanism that allows the current system to really quickly adapt to, you know, newly emerging need, to unmet need. So grant funding, I think, plays a really important role to plug those gaps and direct funds to work with people who otherwise would not have the ability to seek justice. There is also, you know, legal assistance provided through the civil legal assistance offices. Again, this is a model where a lot of the bureaus work, you know, signposting people to those. But more and more bureaus are reporting to us that they are unable to access support from their clouds at all at certain points in time. That can be because of geographic restrictions or because just they have limited capacity as well. And it's the same with signposting to other third sector organizations. A lot of them, I mean, I'm not sure that I'm speaking beyond my capacity, but I think a lot of us are really stretched, and we're having to do more with you know, less funding. So strengthening that mixed model, you know, could be a real kind of way forward in being able to really channel money to where, you know, it's really urgently needed and where more longer term reforms need time to really set in. And yeah, as I said before, I think early intervention and prevention are really key. So focusing on less stressful, less costly, and earlier resolution of legal issues where possible. Kind of also efforts to maybe improve the ways that the whole advice sector works together, you know, better triaging and enhanced resourcing and promotion of alternative dispute resolution where this is suitable and appropriate. So yes, we would really like to see more discussion about what a mixed model could look like. Thank you.
I think the overwhelming priority needs to be the urgent reform of duty care, right? Because that is where that's where all the action is just now. So that has to be the overwhelming priority. The mixed model system is positive, though. The grant funding, you know, we're a recipient of grant funding via Rape Crisis Scotland for the Scottish Women's Rights Centre, alongside the University of Strathclyde Law Clinic. And it has, you know, I don't know whether I would use the phrase plugging the gaps, but it allows us to collaborate with different organisations. that in turn gives you, you're pooling your resources to a certain extent. We're getting a lot of, they're getting a lot, Rape Crisis, for example, are getting a lot of information from our legal service. We're getting some really great information from their survivor groups or from, trainings that we collectively provide. The advocacy service there is able to work hand in glove with the legal service. Right? This is critical for women who are affected by, for women fleeing domestic abuse. The grant funding allows some of that, which is really important. So I think the way I would look at it more is like, where are the real groups and areas where this is really going to add a lot of benefit over and above what's there in Judicare. Obviously it has its problems though. It's a tiny amount of money, as Hio said, and candidly these days it doesn't cover the costs, so it's been subsidised by charities like ours. And very often you don't know whether it's going to be funded until sometimes days before the funding runs out, which is not a good place to be if you are a charity providing a state-funded service.
Thank you. If I could ask again about the government's intention to embed the user voice in the planning process for legal aid delivery. How practical do you think that would be? And we've heard different examples of vulnerable people. That might be an adult with incapacity, a homeless person, someone under coercive or abuse or financial control. So how practical do you think that ambition will be, and how do you see it working? I'll go back to Andy first.
That is a good question. I don't know the answer to it, to be honest with you. It would be very important because it's clear that, I think everybody's in agreement, including the Legal Aid Board, that the system is not user-friendly. And the voices of the folks that we're talking about on this panel who are trying to access our services are not reflected in the way the system is structured at all. How we do that is probably beyond my level of expertise, I would say. This really requires a human rights-based and a participation approach. Now, there are organisations on this panel who I think have that expertise within them, and perhaps looking to the grant-funded partners in order to provide that. But it needs to be a little bit broader than that, isn't it? Because I suppose the theme of this session this morning is that there are a lot of people out there who never see it. And how do we bring the system to them? I don't know the answer to that question, to be honest with you, but I know there are people who do know the answer.
Would you like to add anything?
Well, I think it's really important to acknowledge that there is, I think as I said earlier, there is currently no real mechanism to allow for, the views of rights holders to inform how the service is, how legal aid is being administered, how it's managed, how it's funded, who it's funding. There is too little of that and too little engagement. I think generally one has to be careful. Not every, participation is meaningful. Often people have, it's much easier for particular or it's much more difficult for the most vulnerable, for those most marginalized to actually be part of those processes. So real effort has to be made to include those people. And I think generally more regular feedback mechanisms would be really important. We hear, for example, from grant-funded projects in our network that there is maybe not enough direct kind of conversation with SLAB on you know, about how these projects are actually making a difference to the people who are coming to it for advice, and to hear what they would actually like to see, what they would really need to happen to be able to, you know, seek recourse. So those kind of built-in mechanisms, I think, would be really important, rather than just having an advisory panel or something once.
That's helpful. Thank you, Sally.
Yeah, just to come in on that particular point around grant funding, there certainly is scope within the reporting for that to be looked at more. Certainly at the moment, the reporting is quite, I think, within one of the submissions, it was described as having a bit of a micromanagement focus. And we wish to see it have more of an outcomes focus and perhaps an impact focus. So, yeah, I would agree that there is scope there around grant-funded projects feeding into that. Certainly, Shelter Scotland, we embed lived experience within all of our work, and we have mechanisms in place to do that are already established that we could certainly roll out within our grant-funded projects.
That's helpful. One final question, just perhaps you could go first, Sally, in that in relation to what you've just said, and that's whether the longer-term reforms should be focused on intervention and prevention at an earlier stage.
Mm-hmm. Well, of course, anything that focuses on intervention and prevention is welcomed, but I think certainly in an older Scottish Legal Aid Board report, there was some indication that, you know, research shows that people are still, unfortunately, going to end up in difficult situation, no matter how much you have that focus. And so, yes, have a focus on that, but not to detract from what's needed in terms of short to medium-term reforms on the current legal aid system.
Okay. Anyone like to add? Andy?
I would come in and say I agree with Sally. Intervention and prevention, great. It is the system as it stands is not particularly geared towards that. You know, the very low eligibility rates for advice and assistance, which is the primary means that you do intervene and resolve issues before they go anywhere near a court or anything like that. Is the eligibility rates are massively exclusionary. So, you know, to an extent, the system's kind of on its head a little bit, unless you're able to squeeze through those rates. But I think that I think it is important to have a focus on that. But as Sally says, you know, very often these issues end up in court anyway, despite our best efforts. So, still needs to be.
Anything to add?
Well, I think just on the issue of funding, first of all. So I think we've always been advocating for, you know, wider access for rights holders to kind of grant-funded projects on a national basis. I think right now it's still a lot of a bit of a lottery to see where. So there are legal aid deserts, but it's not really matching up necessarily with where those projects are available. And we would really need longer-term funding to develop a more sustainable institutional landscape of access to justice support more broadly. With early intervention and prevention, well, I mean, we do acknowledge, of course, people will need to go to court, and they should have, you know, all the support necessary to do that if they need to. But just we just really need to address, you know, a lot of wider problems that come, basically, that people are facing with such issues. And there can be, you know, there's the whole legal aid system which really needs a huge overhaul, but then there's issues around court fees, there's issues around the digitization of the justice system that is excluding more and more people. and we are in this process of, we are at a time in Scotland where more of our human rights are being promised to be incorporated. And so legal aid will play a really crucial role in allowing and enabling people to really seek remedies for rights breaches. And it's the same with now the kind of progress on mainstreaming equality and human rights across the public sector in Scotland. So, there is a real need to look at this urgently and to bring in these reforms, not later and later, but really now, and start work on it.
Okay, thank you, Convener.
Thank you. And then move on to questions from Tess White, please.
Thank you, Convener. If I can start off with Andy. Andy, you talked about urgent reform of Judicare. The whole system needs looking at. I mean, we're entering a landscape now where, take CAB in their response, said that they've got 25% increase of cases and the system is broken. Bearing in mind that tight funding, because everybody wants more funding. But what would you say what key actions need to happen to look at the whole system and improve a broken system in terms of delivering this human rights?
Well, I'm glad you asked that question. And yeah, there's a lot. Okay, so when it comes to creating the efficiencies, I genuinely believe that if we create the efficiencies that are set out, for example, in our written evidence, then we will actually save money on the slab side of things. Okay, because I told you before about the kind of double audit, the slab approving every single little piece of work that gets done in advance, and then slab auditing everything at the back end a second time round. Now, I don't have the figure to my hand, but in the annual report that the Legal Aid Board provides, they tell you in the pie chart how much money they spend on the administration of these things. And I think if we are able to reduce a lot of that administration, or reduce a lot of the time we spend engaging with Legal Aid Board, and the Legal Aid Board engaging with us, then we would be able to make some savings, I actually think. So, we've spoken a little bit about the fee rates. We've spoken about already the very low initial limits that you get. When I open up a file, it's £135. Well, I spend that during my meeting with my client. More administration there. We've spoken about the need for templates, the need to reduce the increase system, and we've spoken about the need for reform of the civil legal aid system. All the documents that you need to provide to the Legal Aid Board in order to even open up a file, 2 statutory memorandums, terminology that is not particularly accessible, client recognitions, third-party statements, months and months and months of bank statements, etc., just to even get off the ground. It's extremely onerous. We've spoken about difficulties and a lot of confusion around special urgency, which I know Sally mentioned. Given the way that the court structure, given the way that the justice system is structured, my colleagues, we use special urgency almost all the time, because in order to raise a judicial review, you only have 3 months. Judicial review is the primary means by which human rights breaches are challenged, and if you bring in that prevention time, trying to negotiate to avoid going to judicial review, you actually end up having a very short period of time to gather all this information and get the action off the ground. Special urgency is a really confusing area with the Legal Aid Board. I don't know. Every time I think I've got it, I realise I don't. So there are significant areas there that we can save on. I know that Aaliyah this morning spoke about abatements. Just to give the granular detail here, I will probably go back to my office this afternoon and negotiate with the Legal Aid Board over sums of money that are down to £7.50, £15.25. You had a meeting that lasted 1 hour. We think it should only have been 45 minutes. That's the level of granular detail that you're in, right? Not only is that a an unwise use of my time. It's a really an unwise use of their time, to be honest with you as well. It gets to the point where for people like us, you're spending more than the value arguing about that sum of money. And that level of complexity in administration is permeated all throughout the system. So if we could somehow work together and pull some of that out, then we will be able to produce something that works a lot better for the people we're trying to help. And I mean, to zoom out for a moment, the reason why that's so important is not only is access to justice and a legal aid system, a functioning, efficient legal aid system, a human right in and of itself, but this Parliament has been passing legislation to advance human rights and are trying to pass legislation to improve protections for domestic abuse survivors, etc. We've got the UNCRC Act that was passed as well. Well, the mechanisms that are in those pieces of legislation are really only able to be used if this legal aid system works properly.
Okay. So what you're saying is an holistic review and a root and branch looking at all the different pieces and how they interact.
Yes.
The whole system.
The whole shooting match.
Go back to the drawing board.
Yeah, and there's detailed solutions in the written evidence.
Thank you. That is really helpful. And in terms of CAB, because I mentioned the 25% increase, and from the submission, was there about saying 4,000 cases a month? Is that true?
No, there is about 3,300 cases or pieces of advice on legal proceedings,
yes,
generally a month.
Okay.
And about 2,700 on legal aid in particular.
Wow.
And that is, I think there's about 4,000 pieces of advice on solicitors and advocates as well. So there's, you know, a huge demand for advice on how to find a solicitor, how to engage in the legal aid process, what are the criteria, people coming to us with problems that they experience with the application and so on, or with finding somebody who will actually take on their case.
So if you were to wave a magic wand, what actions do you think should happen?
Well, that's always really difficult to answer, but I think in the immediate term, as has been discussed in quite a lot of detail in the morning as well, is really simplifying all the administrative processes around it. I mean, we are not legal practitioners, but what we see is a point of view of rights holders who really need to get through those stages to see kind of remedies. And it is so complex and really difficult to understand for people. And the evidence that has to be submitted in forms and so on can be really tough. And as you said, Sally said in the just before, that it can take quite a long time for a final decision to be communicated to clients. So anything that can really help to make that easier.
So
simplifying it would already be a really good step in the right direction. But then there are much broader problems, yes, with Judicare. How can we make sure there is really, you know, there are the legal practitioners on the ground so that these are, access to justice is really available in practice, not just, you know, on paper as something out there, but then not really, cannot be really realised for everybody.
That's helpful. And Sally, for Shelter's point of view, this massive crisis in homelessness and making sure that there is a human rights approach to justice, what actions do you think should be taken?
Well, I think, I've said before, I think we're at the stage now where we have to recognise that there is a crisis in access to justice in terms of particularly people experiencing homelessness accessing solicitors. And there are many proposals that have been made in the course of this inquiry which can be taken in the short to medium term. My colleague Andy has highlighted many that can be taken purely by amendment to regulation rather than looking at bringing in primary legislation. So the focus needs to be on that because those are the underlying reasons for there not being enough solicitors to allow people to access and enforce their rights. So certainly simplification of the legal aid process, and also a review of the fees, which, you know, part of why there are a lack of solicitors is because there is a requirement to do a significant amount of unpaid work. So all of those underlie the reasons that we see access to justice crisis, particularly in relation to homelessness advice.
Thank you. So my final question then is around, is there anything else? So are there any other issues that you'd like to raise with the committee? So if we start off with Sally, and then go to Yoshin, and then Andy.
Yeah, so I mean, a particular, and in fact, one of the overriding concerns for us does revolve around grant funding. So we very much welcome being the recipients of grant funding, and that allows us to provide advice, for example, representation in court where people are at risk of losing their home, either through eviction or mortgage repossession. In the Borders, Tayside also, but the Borders in particular is known to be a legal aid advice desert. So without that grant funding, we wouldn't be able to cover that area to the extent that we do. So grant funding is particularly welcome for us, but it's not to say that there aren't issues there. In particular for us, it is the year-on-year nature of the grant funding. I can't really stress enough how difficult that is for us as an organisation to deal with, and the impact, the real-life impact that has. The responsibility here does sit with the Scottish Government in terms of taking decisions on grant funding, and so we would urge the committee to call upon the Scottish Government to extend the period of grant funding to 3 to 5 years, and also to try and avoid the delays in decision making that we've seen. So just to give an example of how that impacts our work, towards the end of last year, we were in the position where we were required to recruit solicitors, but we're unable to do that because we're awaiting decision on grant funding and the potential impact that might have on us. So for us as an organisation and the law service, in real terms, what that meant is that we were not able to provide a level of emergency service that we do in terms of street homelessness across Scotland's largest cities, particularly Glasgow. So there is a very real impact on the users of legal aid and some of the most vulnerable in our communities around delays in grant funding, and also just the instability that the short year-on-year funding provides.
Thank you.
Yeah, I would completely echo that. So this is also the experience that we have in the network with grant funding. It is really difficult to even maintain a level of service, and that money could be so, you know, much better spent or that money would go much further if it was not that annual funding cycle that makes everything really so precarious for the staff, for the projects, but of course, in the end, for the rights holders who come to us for support. I think there is, you know, there's a lot, I think, to be said about what could the legal aid system look like, and what would we like to see happening. I think there is, you know, in terms of grant funding, for example, just in October, I think last year, some funding was pulled from some of our grant-funded projects. That was the Stream 2 funding, which provided support to people with going through a simple procedure. And that's generally also not covered by legal aid, legal assistance funding. So it's an area where we've seen sustained advice need. But the decision was made to no longer provide that funding. And again, it's a question of who else, you know, where is that support going to come from? How are people going through these proceedings without any help? And often it's basically just has to be provided by the bureaus, again, through the general advice provision, and which puts again pressure on already stretched services. I think there is a need generally also to really look at it from an access to justice, human rights-based point of view. So looking at access to justice reforms more widely, that kind of includes, but goes beyond reforming just civil legal assistance and the legal aid system. I think it's probably not a good idea to open up that box when we have already something so big to reform, but I think generally for people that come to the network, it would be really important to enhance kind of the potential of non-judicial routes as well to justice, so including complaints mechanisms, ombudspersons, how tribunals work, what kind of support people can get for those steps. So it's a kind of broader access to justice landscape that we need to look at. We also need to strengthen the collaboration between different sectors, stages of advice to support rights holders on their justice journeys. Again, we should review current levels and exemptions from court fees. We've heard in the morning and previously how eligibility criteria are, kind of eligibility thresholds are just really too low. We see this growing justice gap where people don't qualify for legal aid, but they really don't have the money to pay privately. And so, a broader section of society is being really excluded from seeking justice. And I think one important point that maybe we haven't really mentioned today was reforms of the criteria for standing in proceedings to allow organizations to take on kind of strategic litigation in the public interest. We do come across, we are not lawyers, and still we come across cases where there is a broader public interest. But the individual who might not qualify for legal aid, the burden and the risk is just too big to take it on.
That's fine. I think in the pressure for time.
Sorry.
No. Would you say, in a nutshell, that's the key points about the issues? And you've got a very extensive submission that we have read. So thank you. And if there's anything else, please do write to us in addition to the submission and that right now. And Andy, do you mind closing and saying, is there anything else that you would like to flag?
Yeah, and I can be brief, don't worry. Legal aid is probably not something that comes up on your doorsteps when you're out canvassing. But I'd like to reiterate that it is a core element of a democratic society. It is central to the operation of the rule of law. We're in a situation here where I think everybody agrees that reform needs to be made. There is some disagreement over what those exact reforms are, but I think that we can find a way through that, and this committee's inquiry will help us do that. In the submissions, we've set out what can be done by secondary legislation, what can be done purely through the discretion of the Legal Aid Board. I think we should be crystal clear on what can be done now, because whatever can be done now needs to be done now. I note that, on the Advice Deserts point, SLAB are pushing back on that, and they are bringing some statistics around that as well. I think I would just draw your attention to the fact that they do not have the statistics of the people who approach services and are turned away. They only have half the story, because their data is only people who have made legal aid applications. By definition, they have a lawyer. I would endorse what my colleague said on the grant funding points, particularly the cycle. And I would just finish by saying that the reform needs to be based on trust between all the parties. We are a regulated profession, very highly regulated, officers of the court. It will only function if we trust each other. And that needs to be at the centre of what we're doing here. And I would, it would just be so nice to come along here again in a few years' time and imagine a system where, a legal aid system where we've not just stemmed the bleeding, but we're actually in a situation where it's growing, where people want to open up a practice in Harris to support folks who are needing help out there. that's really what we want to be doing, and I think it is achievable. But we do need to trust each other and move forward. Thank you.
Thank you.
Thank you. Are members content that they've asked everything that they would wish to? Yes. Well, thank you once again for your participation this morning. It's really essential to the work that we're doing at the committee. And we are now going to close this public session and move into private to consider the remaining items on our agenda. Thank you.